Uh-oh, where's Jared and Rob? This is a great start here. Hey everyone, welcome to episode 33 of Trucksafe Live, show where we and our guests tackle the hot button issues impacting highway transportation. I'm Brandon, that's Jared. Rob's coming up here in a second. There's Rob. All right, great start here. Like I said, episode 33 of Trucksafe Live. Today we are kind of doing a year-end review. Yeah, you would think after 33 shows I could get this right one time. But anyway, welcome everybody. Thanks for being here with us. Happy holidays to everybody who's tuned in. If you're here with us, say hey in the comments so we could see who's with us. And yeah, you're in review show today. So we're going to take a look back at what this year had in store for regulated trucking companies in terms of regulatory developments, and then also looking ahead to what could be in store for next year. So should be a good discussion today. We published an article about this on our website earlier this week. So if you don't want to watch us talk about it, you can always go over there and check it out. Matt says, happy holidays. Happy holidays to you, Matt. But anyway, before we get to that fun stuff, let's talk about some things going on over at Trucksafe. I usually write this stuff down, but I just realized I didn't write this down this time. So what do we got going on at Trucksafe, guys? We got a ton of stuff going on.
Yeah, we got a lot of things that are going to be happening in Q1 for sure. So look out for some announcements that'll be coming Q1. But we've been very busy with the consulting work, very busy with the course development, course sales. So if you haven't checked out Trucksafe Academy, definitely check out the courses that we have to offer.
Yep, we're also in the planning stages for our next Trucksafe Fleet Compliance Boot Camp. We've had a lot of people asking about this, so just an update on that. We're targeting summer of 2024 for our next Trucksafe Fleet Compliance Boot Camp. We're probably just going to do one next year as the plan, and it will probably be somewhere around the Nashville area. Last year we did one in Indianapolis, and then we did another one in Orlando, so we're going to try and pick somewhere kind of in the middle this time. So be on the lookout for that. Best way to keep up to date with that type of information is by subscribing to our newsletter, which you can do at trucksafe.com/subscribe, and not only get those types of updates, but also we send out the latest breaking regulatory news and our analysis of it and that type of stuff. So check that out again, trucksafe.com/bootcamp, or I'm sorry, trucksafe.com/subscribe, and then the boot camp information is trucksafe.com/bootcamp. Anything else, Rob? What else we got?
No, we've got some rating upgrades and getting people back in business when they don't do right and they need that sort of thing.
'Tis the season to hopefully stay in business.
Yeah, right. Yeah. Other than that, some general consulting stuff and trying to keep it floating.
Yep. Yeah. If there's anything we can do to help you guys, fleets out there watching, feel free to give us a shout. Doing a lot of consulting work, as Rob said, and safety rating upgrades, data queues, whatever you got going on. If there's anything we can ever do to help, feel free to reach out. So it's pretty much what we've got going on. Looking forward to, like Jared said, we got a lot in store for Q1 next year. A lot of announcements that we will be making here sooner than later. So be sure to stay tuned for that information. But anyway, enough about us. Let's talk about regulatory year-end review and 2024 outlook. So like I said, this kind of started with an article we put out earlier this week, kind of highlighting some of the most significant DOT rulemaking activity and non-rulemaking activity. We'll get into that in a little bit. Over the course of the last year, it's a fairly busy year. I thought it was going to be pretty slow again when the year kind of started out, but then it turned out we actually had quite a few regulatory developments that we'll get into here in a minute. So I think that's the best way to go about this. We'll start out with kind of looking back at those developments over the last year, and then some of those, as we'll talk about, are going to bleed over into next year because they haven't been fully implemented yet. But then we'll kind of conclude with what could be in store for next year. As we go along, as always, if you have any questions or thoughts on these issues that we're discussing, throw them in the comments and we'll bring them up. All right, first things first, guys. First thing on my list here. from regulatory developments from 2023. Perhaps the most significant one of all came early this year in February of 2023. FMCSA announced fairly significant changes to its safety measurement system, its CSA scores. And we had an entire episode of Trucksafe Live dedicated to this particular topic. We broke down exactly what the FMCSA was proposing. As we said in that episode, this was a little bit of a surprise. We knew that FMCSA had been told by Congress that they needed to make changes to the SMS. We just didn't know that they were at the stage yet of actually being ready to make those changes. But in February, we got the notice that they are proposing, it was a handful of fairly significant changes, which we can talk about. But that one really kind of caught me by surprise. How about you guys?
Yeah, definitely. I mean, the movement away from IRT, the item response theory, because it certainly seemed like the agency was pushing towards IRT, and then the movement away from that was a bit of a shock to me. We knew something was going to happen, but we weren't really sure what it was exactly going to look like. But a lot of changes.
Yeah.
Yeah, I actually like this one. I think a lot of it made a lot of sense. I don't always give the changes that credit, but in this case, I think it did make a lot of sense. Like combining or splitting vehicle maintenance into two different categories, moving drug and alcohol to unsafe driving. It was just common sense things that probably should have been done a long time ago, and we just kind of finally got to it. And some of the other things, paying more attention to recent violations. So I think it couldn't have been better.
Yeah, I'm right there. I'm right there with you. I think overall, my kind of thoughts on it, generally speaking, were that they are welcome changes once they take effect. These haven't taken effect yet, so this is one of the activities that will bleed over into next year. We don't really even have a date yet of when the FMCSA is expecting to roll these out. What we know is that they proposed these this February 2023, and that they set up a preview website for it, so where carriers can log in and see how their scores are going to be impacted by these proposed changes. If you haven't done that yet, if you haven't logged in to look at how your scores are impacted by these changes, I'd recommend you do so because it has the potential to change your scores. That said, I don't know about you guys, but I've worked with a few clients to kind of look at what their scores would be like under the new system, and it didn't seem to make all that big of significant changes to their scores. Did you guys have different experience with that or no?
No, I didn't. I think, besides what I said in terms of liking it and agreeing with it, I think there is that piece with carriers that, I think a lot of carriers didn't really understand how it worked even under the old system. So now they're finally, in some cases, just getting to the place where they're familiar with it and they're understanding how they're rated. And now there's going to be some changes that could change it. But like you said, I haven't found where it really affected it all that much. So I don't think they've got a lot to learn, but I think it's going to change a little bit of what they may have just figured out from the old system. So,
well, you mentioned one that I think is probably one of the more significant ones, Rob, which is that splitting of the vehicle maintenance category into two separate categories. FMCSA, for those not familiar with this change, is essentially, currently we've got our 7 basics that make up our CSA scores, one of which is vehicle maintenance. And the proposal is to split that vehicle maintenance category into 2 separate categories. One will be called vehicle maintenance, as it is now, and then the new one will be called vehicle maintenance driver observed. And the idea with this change, as I understand it, is this is the basic that currently has the most data in it. It turns out that vehicle maintenance violations are the most frequent types of violations encountered by regulated trucking companies. So there's a lot of data in that basic, and it makes it difficult for carriers that are struggling in the vehicle maintenance basic to understand what's the root cause of their problems in the vehicle maintenance category. So the idea with this change and splitting it out into driver observed and just regular vehicle maintenance is that if going forward I have a high vehicle maintenance driver observed category, but then an okay regular vehicle maintenance category, then I can deduce from that the issue, one of the root causes of my maintenance problems, is probably insufficient pre-trip inspections by my drivers, because that driver observed category is going to be all of the maintenance related violations that the FMCSA says should have been caught by a driver in a thorough pre-trip inspection, and that weren't for one reason or another. Any thoughts on that change, guys, specifically?
That's where my mind went too when Rob was talking about the maintenance changes. I love the driver observed category because a lot of times carriers are confused on how they get maintenance scores under control. But with that driver observed category, you're clearly, like you said, going to be able to point back to proper pre-trips, post-trips, en route checks, to driver observed issues that should have been caught in a proper pre-trip or post-trip.
Yeah. And sometimes you have that dynamic in carrier operations where you've got that lack of collaboration, let's call it that, where you've got that systemic problem that's maintenance driven. Maintenance isn't doing everything they should be doing to run that maintenance department. I say in a predictive fashion, but they're typically kind of at war with that frontline driver piece, where the drivers are saying, "Hey, it's not us," and the mechanics are saying, "Hey, it's not us," and nobody can ever really trend out like who's the real
it's like that meme with the Spider-Man pointing at each other, kind of.
Yeah, exactly. But it's all one operation, so it's ultimately a management issue. But it could be both. It could be systemic and driver focused. But this will help you trend it out better to where you know what it is and how to.
Yeah, I think it'll be particularly helpful to the carriers, of which there are many, that don't spend a ton of time digging into the data. In other words, I feel like it will give them an easier way to see at a glance what their maintenance problem is. Is it something that my drivers have better control over, or is it in the vehicle maintenance category where they are more like latent defects, actual mechanical issues with the truck that is suggesting that we've got an actual maintenance problem more so than a driver inspection problem. So yeah, I think overall, like I said, I think the changes make a lot of sense. I get the sense from talking with clients too that they're generally in favor in most of these with most of these changes. That said, there are some notable absences from the proposals that I think a lot of folks were hoping the FMCSA would address through the changes, including most notably, I think, the long-standing problem that many folks have had with the CSA program, which is the kind of regional disparity of enforcement of the safety regulations. In other words, carriers domiciled in certain states or that have more regional operations in certain states who are more aggressive in writing up speeding violations, for example. Indiana is the classic example. Tend to have a higher score in that particular category than similarly situated motor carriers. So what ends up happening is we end up punishing motor carriers just based on where they are domiciled in the country, essentially, which is obviously not what we want to happen with this type of system. So I think a lot in the industry were hoping that the FMCSA would do something about that, but they specifically declined to in their notice. So we'll see. We'll see if that ends up, because what we're essentially getting to here is U.S. Congress was the one that kind of initiated this and said that the FMCSA had to make changes to the system. Ultimately, FMCSA is going to have to make changes and then get Congress to sign off on what changes they made. So once we roll out these changes and FMCSA has to go present them to Congress, we'll see what Congress has to say, I guess. Okay, that was the first what I would consider significant kind of rulemaking activity, although it wasn't really initiated as an actual rulemaking. The CSA program, for whatever reason, hasn't been implemented through any formal rulemaking. So these notices of these changes really just was a notice. There was no formal notice of proposed rulemaking or anything like that, which is fairly significant. But in any event, next one up on my list here. Changes to the way that we do clearinghouse notifications. Rob, you want to break this one down for folks that may have not been up to speed on this one?
Yeah, I think this one makes a lot of sense too, actually. They're batting 2-0 so far. So with the clearinghouse notification, what was happening is you might run it in January and then not run it again until next January. And then during that time, it's kind of like the MVR thing. You get a ticket, nobody knows about it until next year unless you happen to be using Samba. Well, this is kind of the Samba of clearinghouse. So when that driver doesn't like working for Trucksafe and they go apply for Driver Reach or whoever the carrier might be, just using those two as an example, and you don't know it, but they do their pre-employment drug test, and then you get a notice that says, hey, Rob has new information in his clearinghouse file. You need to go pull a full query. So
what could that information be?
What could it be? You get consent from the driver to get that, to pull that again. You look at it, see what it is, and lo and behold, you see, hey, he's done a pre-employment test trying to get another job with another carrier. Well, now he has an issue with getting that job with the other carrier because he failed the pre-employment test, but now he also created an issue with his current employer because he's now prohibited in the clearinghouse until he completes that.
You really screwed yourself that time, Rob.
Yeah, I did. It happens. We actually had it happen. We had a driver. We didn't know he was not happy. He went and applied at USA Trucking, and sure enough, we got it. We got the notification. Mm-hmm. I mean, this was some time ago, but we got the notification, and now he has no job because at the time we didn't do so. So,
yeah, I mean, it seems to close a pretty big gap, a pretty glaring gap in the clearinghouse process, which was, as you said, potential existing employer potentially being blind to a driver's positive test at a different motor carrier. And so by automatically notifying motor carriers now, this change has taken effect. So this is how it works now. You automatically get notified through the system if there's been any change to your driver's status in the clearinghouse within 12 months after you run one of your own queries. Jared, anything to add on that one, or that was pretty self-explanatory?
It's pretty great. It alleviates a potential 12-month blind spot between limited queries. So, I mean, it's a no-brainer. It's a good move.
Now, one thing I just realized that this isn't on our list on our article. I should revise that article to put this on there because it's pretty important. Another clearinghouse change that is scheduled for November, I think, of next year, is the next phase of the clearinghouse implementation, which is a deadline for state driver's licensing agencies to take action upon receipt of a driver's prohibited status in the clearinghouse to downgrade their CDL automatically. Right now, that doesn't necessarily happen. Some states do that, but it's not mandatory. But as of November, I think, of next year, it will be mandatory that as soon as the states get a notification that any CDL driver domiciled in their state has been put into prohibited status in the clearinghouse, they have to automatically downgrade their CDL, which closes yet another gap in the system, which was if Rob gets his CDL downgraded because of a drug testing violation, then he could theoretically still have a valid CDL to continue operating, even though he's technically prohibited to operate because of that drug testing violation. So I think that'll be a good change that is, like I said, scheduled to take effect next year. Tom Cuthbertson, hey Tom, is asking on LinkedIn. I think this is going back to our first topic here. Are they also looking at some of the severity weightings for the SMS changes? Yeah, my recollection is that is one. They're actually considering a complete overhaul to the way that they do severity weightings, because that was one of the big criticisms of the National Academy of Sciences when they came in to study SMS at the direction of Congress. One of their criticisms of the system was that the existing severity weighting severity weights of 1 to 10 for all of the violations seem to be completely subjective. In other words, what weight a particular violation got assigned was not, as you would expect, driven by data to suggest how likely that particular issue is likely to cause a crash. You might think that that's the way to do it, but apparently FMCSA, rather than doing that, basing it on data, they just had subject matter experts within the agency say, yeah, I think this particular violation should carry this particular weight. So it was completely set very subjectively. So to ostensibly address that concern, one of the proposals with the SMS changes is that we're going to move completely away from a 1 to 10 severity weight system into a system where violations have only a weight of either 1 or 2. And which ones get 1 and which ones get 2, it turns out that the ones that are going to be 2-pointers are going to be out-of-service violations, essentially. So the more serious ones, as you would expect. So any violations that CVSA has determined are out-of-service violations, whether vehicle-related or driver-related, those are the ones that are going to have a severity weight of 2 going forward under this proposal, and then all other violations will have a severity weight of 1. So it'll be either 1 or 2. The idea was to remove some of the subjectivity. Now, I think that introduces actually some additional problems, which is the fact that essentially violations that probably should be treated fairly differently from one another are going to carry essentially the exact same weight. I'm trying to think of an example. Do you guys have any examples of that? Like under that new methodology, like what would be 2 violations? Like a form and manner violation would be a 1-pointer, which is just a minor paperwork violation, but so would things like speeding violations. Right, so they would carry the same weight in the system, but they're clearly not describing the same type of thing or the same type of concern.
And
That's not a great example because those are separate basics. But
brakes and reflective tape.
Yeah, brakes and reflective tape. There you go.
And part of the issue that you're describing too, Brandon, is the fact that they're going to take, like for hours of service, for example, they're going to take the 73 separate hours of service violations that are currently in existence and put them into a combined group of 9 different violation groups. And so that's where you could have broader categories of HOS violations being put in group 9 and all being treated the same.
Yeah, so that is one aspect of the proposal that has gotten some blowback that I've seen. So I guess we were a little quick to say that that we were generally in favor, but some of those things I think we're just going to have to wait and see what the impact is. But yeah, that for sure is being done, Tom. Okay. We've talked about SMS changes. We talked about clearinghouse notifications. Next up on the list, this was something else that happened in 2023, in April, in fact, was the FMCSA's notice that they intend to expand the so-called crash preventability determination program. Another change that I would generally characterize as a pretty good change, a pretty welcomed change. Those who aren't familiar with this system, it is of this program. It is a program in place where a regulated motor carrier can go in and essentially challenge the preventability of certain types of DOT recordable accidents. Historically, all DOT recordable accidents have negatively impacted a motor carrier's crash indicator score in the SMS platform. And it's never been that fair, because why should we be penalized for accidents that were clearly not our driver's fault, the non-preventable accidents? And I think FMCSA's rationale for that to date has been, well, that may be not all that fair, but at least we're treating everybody the same. Every motor carrier gets penalized just as heavily for all types of accidents, whether or not they were preventable. Regardless, FMCSA set up this crash preventability determination program probably 5 or so years ago, where in limited circumstances, motor carriers can file an appeal essentially through the data queue system to challenge the preventability of their DOT recordable accidents. And then if they prevail in that appeal, if the FMCSA decides that it was non-preventable on the motor carrier's driver's part, then that particular accident, it'll still show up in the system, but it won't weigh on their crash indicator score. Now, that program was initially set up as a pilot program, so it was very limited in scope. It progressed out of the pilot stage, but it was still limited in scope in the sense that the FMCSA has an eligibility guide for what accidents qualify for consideration for a non-preventability determination. And to date, until now, and currently, there are only 19 accident types that qualify for consideration. If it doesn't meet one of those, if it doesn't fall into one of those 19 categories, your appeal is just going to get kicked out without any consideration. And it turns out that those 19 categories are pretty narrow. It's going to be the ones that are easy for the FMCSA to determine are not preventable, as you would expect. And so the proposal, long story short here, the proposal earlier this year in April is to expand that program to add additional categories of accidents that will be eligible for consideration under the program. So they're going from 19 to, oh, maybe I had that wrong.
16 to 21.
16 to 21. So there's 16 currently, and they're going to 21. Thoughts on this change, guys?
I mean, it's a welcome change for sure. I mean, talking about the program and the eligibility guidelines, they're very rigidly applied. And so if you're going to consider submitting a challenge to a crash, make sure that you really study the program and the eligibility guidelines, because like I said, they're very rigidly applied. And if you don't fall squarely within one of the categories, it'll be rejected for sure. It is difficult sometimes because you may have two categories that generally apply, and how do you decide which one you want to go for? That is a strategy question. That's an interesting one. But I've seen some crashes rejected from the program that seem to be squarely within the eligibility guidelines. And it's a little frustrating, but hopefully this addition of up to 21 crash types helps with the program. Rob, what are your thoughts?
No, I think it's a good thing. The whole program is not without its workload, I guess. You have to get the crash report. We've done a number of these recently, as you two know, but like one I had kicked back yesterday, it qualified without question, but the driver didn't have a med card that was valid at the time. So their response back was, we need a copy of his valid med card. And it's like, what does that have to do with this crash? So anyway, we supplied it rather than argue the med card, and it eventually got approved. But that was one of the questions that they sent back. So you still have the workload aspect. The good part about it is there's more things that qualify as opposed to what used to qualify as something that you could challenge there. But I like
ridiculous.
It.
Why?
Yeah.
Why?
It was. I think it was Washington. So it's one of the more western states. Let's put it that way.
Oh man, that makes me mad.
Yeah.
Anyway.
Yeah, I'll send that to you.
Yeah. What does the driver? Because forget it. One of the things that I noted about this change that I thought was interesting, so even though they're still going to limit it to 21 crash types, I did notice that the last proposed new crash type seemed like kind of a catch-all that may encompass even more accidents than just the 21, because it was something to the effect of any other accidents in which you have video evidence to support your version of the facts. Essentially, I'm paraphrasing there, but if I understood it correctly, if you've got cameras installed on your vehicles and the camera footage shows clear enough that it was not your driver's fault, even if the accident doesn't otherwise fit into one of the other categories, then you may be able to submit that camera footage and get it removed from your score. So I thought that was a welcome change too. Let's see here. Matt's saying Jared's right on point. You don't get that said very often, do you, Jared? You have a crash that could qualify, but what box do you put it in the limited types? Yeah, I mean, that's the problem. Okay, that's crash preventability determination program. Next up on the list is oral fluid testing. This got a lot of news coverage in this past summer. FMCSA, actually the USDOT more broadly, issued a final rule where they authorized oral fluid testing in addition to urinalysis as an approved test type for DOT mandated drug screens. And that, like I said, that came out in May, but here we are in December of 2023, and carriers are still not authorized to use oral fluid testing quite yet. Why is that? It's because that rule is contingent on the Department of Health and Human Services approving at least 2 laboratories to be able to process those test types. and they have not yet approved any laboratories to process those test types. So there's no one to actually process them. So we're still waiting on that. Have you guys heard any rumblings of when that's supposed to take effect? I keep hearing it get pushed back.
Nothing.
I haven't heard either. I have heard some folks excited about the opportunity to use the oral fluid testing, and I've heard some folks say that it's going to be more accurate. Some folks say it's going to be less accurate. What's the reality there on the accuracy of the testing? I mean, I know it's going to be a less invasive means, a little easier to implement, ideally, once we get the labs up. But from an accuracy standpoint, is it going to be improved accuracy?
I think there was some data in the final rule where they kind of studied that, and I think it ended up being kind of a wash because for some drug types, I think it had a longer detection window, and then for others, it had a shorter one as compared to your analysis. That was my understanding. Rob, do you have any experience with oral fluid testing from when you managed safety programs?
We did it from a non-DOT perspective because it's like $9 a test versus the cost of a urine test. And if you don't have to have urine for non-DOT, go the cheaper route. But
what's the average cost for a urine test? I don't even know.
I don't know, $30-$35, something like that. But it depends on who you're using too. It could depend on lab, a vendor, etc. But the only issue that we ever really had was for non-DOT was if you had the argument of, hey, I want to check the second specimen. There is no second specimen in the non-DOT case. There is with the new rule for DOT CDL people, but I never really came into it just you either were or you weren't. So we never really got into trying to figure out.
Yeah, I think from what I understand, the big impetus for this is two things. Jared, you mentioned one of them, which is the relative ease of administration of these types of tests as compared to your analysis. And also, perhaps more importantly, the fact that these oral fluid tests are, by their nature, always observed by the collector versus your analysis, which is very rarely observed. And so the prospect of drivers cheating on a urinalysis test, as I understand it, was much higher than their potential ability to cheat an oral fluid test because there's somebody right there in front of their face watching them spit into the tube or however they administer them.
Yeah, we did find another good benefit to it was it usually came back faster. So that's obviously going to depend on the issue and how that works itself out. But in our case, it generally came back pretty quick. So
yeah. So I think it'll be good that carriers will have another option for administering these tests. You'll want to, if you plan to administer these types of tests, you'll want to make sure that you update your drug and alcohol testing policy to make sure that it's clear to your drivers that this is a possibility for them. But again, they're not authorized quite yet, so be on the lookout for the notice once the DOT sends it out that they've approved or that the Department of Health and Human Services has approved those labs. We'll also obviously notify our clients of it. So again, another reason to subscribe to our newsletter. Okay, that's oral fluid testing. Next up, this was another big one that we actually knew this one was coming down the pike, but it's in its very early stages now. So this is potential changes to carrier safety fitness determinations, also known as safety ratings. So motor carriers who have a safety rating will be familiar with this process, but essentially we have had this 3-tiered safety fitness determination process in place for decades at this point. Carriers that have gone through a comprehensive DOT audit will often have a safety rating of either satisfactory, conditional, or unsatisfactory. This has historically been the way that the that the FMCSA has enforced its safety regulations, is on and off-site audits, digging through records, and then assigning a safety rating. If you get an unsatisfactory rating coming out of an audit, then your fleet is going to get shut down. So this has been the primary enforcement tool that the FMCSA has used, but it's showing its age at this point. And one of the big criticisms, I guess two big criticisms with the existing safety rating methodology is, number one, just so few motor carriers have a safety rating because the FMCSA just is not able to effectively conduct audits of very many motor carriers. I think upwards of 95% of the regulated carriers in the country don't have a safety rating. So that's the first concern, is that, there's just, it doesn't touch enough touch enough of the regulated motor carriers that we have operating out in the country. And then also another big concern with it is that safety ratings and audits in general are, by their nature, just a snapshot of the motor carrier's safety performance. In other words, DOT's coming in to do an audit, they're looking at your records as they exist today, and they're basing your safety rating on how those records look today. But those ratings say nothing about what your fleet is looking like as of the current day. So maybe your rating was issued to you 20 years ago, and you've since invested a lot in your safety program and made all of these great changes to improve your compliance, but you're still living with that same safety rating downgrade that you got from 20 years ago. So like I said, by their nature, these ratings are static, and as compared to like CSA scores, which are looking at kind of a rolling data set from month to month basis. So FMCSA came out with a notice. This is actual rulemaking. It's in the advanced notice of proposed rulemaking stage. Came out in September. According to the notice, FMCSA is interested in developing a new methodology to determine when a motor carrier is not fit to operate CMVs in interstate commerce. But what does that look like? How's it going to work going forward? We don't know. The FMCSA asked the public to weigh in on that question. They listed out several different questions, and they opened it up for comments, and there have been hundreds, if not thousands, of comments filed. But we won't know until sometime next year, probably, when they come out with the proposed rule. So thoughts on this topic, guys?
I think it's one of those things you kind of got to be careful of when you change it, because it's not just, it's a safety rating. So obviously it's designed to indicate whether you're safe or not, or your operations are. But a lot of people use this from an operational perspective, whether they want to give you contracts to haul their freight, or whether brokers use it to determine whether they want to let you haul their freight based on what your safety rating is or isn't. So I'm interested.
Or insurance groups setting your premiums,
cab reports, etc. A lot of things focus on this safety rating and this data. So I'm interested in seeing how they change it, and if it's a benefit or something that's going to hurt carriers.
Yeah, I've always kind of liked the idea of just a simple fit or unfit, getting rid of the middle category of conditional, because, like Rob just kind of mentioned, some brokers refuse to use a motor carrier that's conditional, others will do it. Is that acceptable? It's just different categories of risk for everyone. So a simple fit or unfit would be a little cleaner way to do it, but that's going to be pretty challenging, because then you're going to have a lot of folks that normally would have fallen into the conditional category that are now considered unfit and unable to operate. Then you're going to have additional safety management plan obligations on the FMCSA's part. With their limited resources, that's just going to be an even bigger challenge. And then also, the audit, you mentioned, Brandon, it's generally a look at the safety management controls that are in place at the motor carrier. And so if you start looking outside of those safety management controls to consider roadside data as a component of fit or unfit, then are you going too far? It's interesting. We don't have a lot of details on exactly how they're going to do it, but that's going to be the most important part, is exactly how they're going to do it.
Yeah.
And we just simply don't know it at this point. So
yeah, for sure. That's going to be the challenge. And we do have a little bit of insight into what FMCSA might be thinking of doing, because folks listening in may remember that the FMCSA tried to do something similar to this back in 2016. They had actually issued a notice of proposed rulemaking, so it was further along in the process than this one, where they had proposed changes to the safety rating process, moving to a fit or unfit determination that was driven largely by CSA scores. So if that had gone into effect, it would have tied directly into the carrier's safety measurement system. And then they had developed a methodology whereby if you exceed certain thresholds within the basics on a given month, then you would be in an unfit status and you would be shut down because of that. And, there was just an outcry in the industry, rightfully so, with that proposal. Because at that point, FMCSA hadn't done anything to address the concerns with safety measurement system at that point. This was before Congress stepped in and slapped them on the wrist. And there were legitimate concerns that the data in SMS just was not effectively judging the safety of the motor carriers for several reasons, including that disparate enforcement issue I mentioned earlier. And so folks just flooded the comments of that rulemaking with hypotheticals of situations where clearly a motor carrier would not should not be subjected to an unfit determination, but under the methodology they would. So long story short there, FMCSA eventually voluntarily withdrew that rulemaking. But my concern is that they are contemplating something similar with this rulemaking, and I think they are taking comfort in the SMS proposals that they've or the changes that they proposed, thinking, well, hey, we've addressed all of these concerns that the industry had with our SMS system, so now we should be able to tie a carrier safety rating to them. They hinted at this in the ANPRM that they published. My biggest concern with that actually leads us into our next big change that happened or that was proposed earlier this year. My biggest concern with that was the lack of due process that's available to motor carriers to challenge erroneous data that's in the SMS system. The platform to do that is the data queue system, as we all know. But folks who use that system know how the deck is stacked against you when you're filing those data queues appeals, because those appeals are in most cases being reviewed by the exact same state agency that wrote you up for the violation to begin with, and they're not often inclined to change their mind about their violations. So the success rate of data queues is very low, and there's nowhere to take further appeals of those violations. If your data queue gets denied, it's not like you can appeal that up to a court system or anything like that. So my biggest concern was, hey, if we start tying a carrier's safety rating and shutting carriers down based on erroneous data, and they don't have any mechanism to effectively appeal erroneous data, what are we doing? And that's where FMCSA came in shortly after they had proposed the change to the safety rating system, and they came out with another proposal having to do with the data queue system. And what they are proposing is setting up an independent appeals board that would be available to review data queue denials issued by states. And I think the idea here is that particularly for issues of like legal interpretation. So if we file a data
matters of legal interpretation or implementation of enforcement policies or regulations.
Yeah.
Very specific.
Yeah, so the FMCSA is essentially hinting at, hey, we're not setting this appeals board up so everybody can appeal to us. We're only going to accept certain types of appeals to this independent appeals board, and it's going to be essentially where the officers misinterpreted the regulations or misinterpreted FMCSA guidance. Those are the ones that are going to potentially be eligible for this type of an appeal. But at least it's something. It's an independent appeals board that will sit above the states, and that will be an additional avenue for us to get some remedy if the officer screwed something up. So I think that's certainly a welcome change.
Absolutely agree. I mean, if you unsuccessfully submit your first data queue and then you take another bite at the apple and submit another data queue request with no additional new evidence, there's a 100% chance you're getting rejected. And so with this independent appeals board, if you qualify for a submission into this appeals board, it's actually going to give you a different set of eyes, not only another bite at the apple, but you're going to get another set of eyes looking at the request. So that in and of itself is a huge improvement in my opinion.
Yeah, we don't have the details on it yet. The notice was short on details and it hasn't been set up yet. So I anticipate that all three of these major changes, the SMS changes, the safety rating changes, and this data queue change will all kind of be rolled into one big change that happens sometime next year, is my guess. Rob, any other thoughts on that data queues appeal
No,
board?
I wish they did more with it, where you could actually push more up, because I mean there are times where that's not the only thing that needs to be reviewed.
Mhm.
So
Yeah. So we'll wait and see how that one plays out. Okay, so with what time we have left here in this particular show, let's hit on some kind of outlooks for 2024, in addition to those things we've already mentioned that haven't been wrapped up this year, that are going to bleed over into next year. What else is there potentially in store from a regulatory perspective for motor carriers? First one that comes to my mind is speed limiters.
Yeah,
Thoughts on
this is
speed
one
limiters?
definitely going to have some activity. It was supposed to have some activity here in December, right? We had a congressional hearing that was occurring that was supposed to be on budget concerns, and the FMCSA administrator was in attendance and seemingly got a little blindsided by some members of the House related to speed limiters and this particular rule. That was pretty fascinating. I don't know if it has slowed the momentum of the agency pushing this speed limiters rule through, but I was anticipating some activity here in December. The month's not over, but it seems like maybe that stalled out a little bit. What do you think?
Yeah, this has been in the works since at least 2016, where FMCSA and NHTSA issued a combined notice of proposed rulemaking that would have mandated these types of devices, the installation of these types of devices on newly manufactured vehicles, and then that just never went anywhere. But according to the FMCSA's regulatory agenda from this year, they had planned to pick that back up and issue a supplemental notice of proposed rulemaking that would again mandate these types of devices. And you're right, Jared, it was originally scheduled for December of this year. But yeah, I agree. I suspect that beating she took at the congressional hearing from a few congressmen, congresswomen may end up stalling this, but we'll have to wait and see. I'm interested in Rob's thoughts on speed limiters, having been a driver.
I kind of split on this one, because there's the safety side of me and the reconstructionist side of me that says like, hey, speed plays a huge role in a lot of serious commercial vehicle crashes. So I understand why we did, why we have this proposal to begin with. But from a driver perspective, that side of me is a little different, because having driven a truck, this and the automatic braking deal takes control away from the driver, and I'm never really I'm not a proponent of taking control of an 80 to 100,000 pound vehicle from the person that's operating it and trusting it to a system. So there's times when you're, especially say, let's just use Colorado as an example, you may need to control the speed of your vehicle in mountainous areas, or whatever the case is, or you may need to overtake another vehicle where you need to go faster than the formerly proposed 68 miles an hour. So I'm kind of both sides on it. I see it, but having driven a vehicle, I see it less.
Yeah. So hard telling where that one's going, but it very well could rear its ugly head in 2024. So again, I have to wait and see. Last few here. This one kind of went dark. So FMCSA had noted this in 2022, and then I heard nothing about it in all of 2023. And this has to do with potential revisions to its ELD mandate. We talked about this on a past show, but some of the things they were toying around with at the time when they came out with this notice was potentially moving away from a self-certification process for ELDs and to a system that's like Canada's, more like Canada's, where ELD devices have to actually be certified by either FMCSA or whatever group it certifies to do those certifications. So that was a proposal, as was potential changes to some of the exemptions that we have for ELDs. The one that they had mentioned was maybe considering adjusting or doing away with completely the older model year truck exemption for ELDs, which says that currently, if you drive a model year engine model year 1999 or older, then you're completely exempt from the ELD rule. And there was some talk in that notice about potentially modifying that. I assume you guys haven't heard any more news on anything like this.
No, I think it would probably be good from a third party perspective, though.
Yeah, I hadn't heard anything additional about this. You're right. Canada requires a third party to conduct a certification of the ELDs that are on Transport Canada's list of ELDs that are approved for use by motor carriers. My understanding is that the FMCSA would be conducting some certification based on the discussions that I've heard, which sounds like a huge lift. But the third party testing, what we've learned from the Canadian third party testing for the ELDs is that it's very costly and it can take a long time, especially if there's fixes that need to be implemented by the ELD manufacturer. And so if the agency were to take this on, I think it would be a very heavy lift. It would get rid of a lot of the devices that we currently have that are self-certified that are causing a lot of problems for motor carriers and the industry at large. So would it be a good thing? Probably. But is it possible? That's another question, because like I said, it's going to be a lot of work on the part of the agency if they're going to be actually doing the testing.
Yeah, I mean, to that point, we have seen, even over the last year, FMCSA seemingly being more aggressive at removing from the list of self-certification devices that it finds to be non-compliant with the technical specifications. I think before this year, could probably count on one hand the number of devices that the FMCSA had removed. But over this past year, I think they've removed an additional dozen or so from the list. So at least they seem to be more aggressive in getting those devices off the list. But yeah, I agree.
I was going to say, I can tell you for sure, previously, a lot of the revoked devices that were put on the list were because of business activity or just a business failing to get traction and market share and then closing up shop. They go onto the revoked list. Well, I can tell you for sure that the FMCSA is conducting investigations on ELD manufacturers that they know are having compliance related issues. So some of the devices that are getting put on the revoked list are because of investigations being conducted by the FMCSA. So they are policing them at this point.
Yeah.
Yeah, and some of these that I've used, it's like if you there's a lot of effort from a carrier perspective that goes into installing these things. And that's why usually I'm pretty big on make sure you select the right one, because once you put it in, it can be, depending on how the size of your operation, it could be a year-long proposal and getting these put in your vehicles and then having to take them back out to only get a new one that works or that's compliant. So if you had a truly objective list that of ones that were really approved, that were really good or compliant, that would be good. But
yeah. Well, like I said, this has seemingly gone dark, so this may be off the table completely. It's not on the agenda anymore, from what I can tell. So, but that's not to say that it won't come back at some point, kind of like the safety fitness determination rulemaking did. So again, wait and see. Last two here. This one, I suspect that there's going to be a lot of folks that are getting a little worried about this one. Potential changes to the new entrant audit process to implement some kind of a knowledge test for motor carriers to be eligible to get a DOT number. So right now, anybody and their brother can go get a DOT number. There's no test in place to make sure that you know anything about the DOT safety regulations. You just go register for one. You can have one in 15 minutes. But there is a proposal on the books for there to be some kind of a knowledge test, so that in order to get a DOT number, you have to either yourself or at least have somebody on staff that knows something about the DOT safety regulations and can pass this type of test. This isn't all that uncommon for like different types of licenses out there that the government, that state or federal governments issue, like some contractor licenses, you got to take a test and that type of stuff. So thoughts on this one, guys?
It's kind of like, it reminds me of E-Verify if on the human resources side of things. If you're going to use E-Verify, when you go to get an E-Verify account to determine if somebody's immigration status is good to be employed in the United States, the first thing you have to do is do their tutorial and then pass like a 20-question test. If you don't, you can never open a case with E-Verify. You can't use this. So it kind of makes sense. And then you have states like Minnesota, for instance, from an intrastate perspective, has a test that you have to take on each basic. But just like with E-Verify, there's nothing showing that you're the person taking the test. I mean, we could hire Brandon or Jared or Rob to take it for us. As long as we have the certificate with the code, we're good. So it doesn't really, it's not indicative that you know what you're talking about. You just hire someone else to take it. We're back in high school again. It's like,
I've said this before. I think this would be a fun Trucksafe Live episode where we get our hands on this test and then us three just sit here and take the test and see who can get the best score on it.
There you go.
You guys up for it?
Let's do it.
We probably won't pass it, and then nobody will ever hire us again.
I think I've got the Minnesota one.
Do you?
I think I do.
All right. Sounds like some good content.
How much time do we have left? 3 minutes? Let's do it.
All right. To wrap things up then, last one on the list here, and this is a big one. Actually, Jared and I did an entire show on this. I don't know. It's probably been a year or so ago, Jared. And this has to do with autonomous trucks and regulations governing those. We know that FMCSA is working on this. To what extent they have this done, I'm not really sure, but it is on their agenda to roll out some regulatory scheme to govern the operation of autonomous trucks. And there's going to be a lot that goes into that. And they kind of started to build a framework for this. They asked for public input on various questions about how these should be structured. But currently there is literally no framework for the operation of autonomous trucks under federal law. So right now it's being governed pretty much just by state law, if the state laws have anything to say on that. So we'll have to wait and see if FMCSA makes any movement on this. I don't think it's going to be anytime in the near future, but it could be in 2024.
Yeah, originally we were supposed to have a proposed rule in December, but yet again, we haven't seen that as of yet. I anticipate, NHTSA and FMCSA will be working together very closely. I mean, they already are, but even more so in the future to kind of get the regulatory landscape under control a little bit. NHTSA is working on a ton of studies right now, tons of studies on AVs, on test tracks, and a lot of those studies are going to yield results here within the next several years, which I think will then speed up the regulatory landscape.
Yeah. Rob, any closing thoughts on that one?
No, I think you'll see more on it. Waymo, obviously the taxi company, which I've been kind of critical of, they put out a study this morning that said out of 7 million driverless miles of analysis showed that there was an 85% reduction in injury causing crashes in autonomous versus driver, true human driven vehicles. So they're claiming that Waymo is safer than if you're being driven by a human, but I don't know that I go with that. But with things like that coming out, it can only be a matter of time before FMCSA has to say something about it.
Yeah. All right, guys, we're out of time. We're going to wrap it up there. Appreciate everybody tuning in. Happy holidays to you. Like I said, if there's anything we can ever do for you, feel free to reach out to us and stay tuned next year. This is the last show for this year, but hope to have you join us next year for some additional shows. So thanks everybody for tuning in. We'll catch you next time.